Well, in that state, I know for certain in that state because I've covered cases there. And in my state, operating a motor vehicle is having the vehicle on and running with access to it. They charge people for DUI for sitting in the driver's seat of a car while
That's
it's
a
running.
completely different context. Just
No,
because
it's
they apply,
not.
yes, it is a completely different Think of the rationale of why they don't want you to tase someone operating a vehicle. It's because the vehicle's in motion. If you're just sitting in a car that's in park, there's no harm that can come to anybody from you being tased, sitting in a car that's running but in park.
Why don't they want someone in the driver's seat of a vehicle that is running, that is under the influence of alcohol?
Because you're about to take off in the car.
And this person was about to take off in the car.
But either the taser would work or it wouldn't. If it worked, they're disabled. They can't take off in the car. If it doesn't work, they're not disabled. They can take off in the car, but then they're not tased.
That's not true.
If they're immobilized by the taser, how are they going to operate the vehicle to put it in gear and take off?
And see, that's the thing. We've seen videos of people being tased. They're not immobilized. I don't know.
But then if they're not immobilized, they're operating the vehicle. I mean, either they're immobilized or they're not.
They're not immobilized. That's the thing, is that we've seen videos of people being tased. Their bodies move when they're tased. That's the risk.
In a coordinated fashion?
Not in a coordinated fashion, but that's, accidentally your foot could stick out and stick the thing into. Now you're not going to accidentally turn the key.
You got to step on the brake, grab the gear shift, put it into drive. You're going to do that while you're being effectively tased?
Well, if the car is in gear, right?
There's no evidence the car was in gear.
What?
There's no evidence the car was in gear. The testimony is that the car was in park.
Yeah, the car goes into gear, and the testimony on this, the testimony was that the car is in park from Officer Johnson, but they haven't testified on this next part yet, although someone could, is that after the shot is when you see from the dash cam the car actually go through and go into gear because the lights on the reverse flash right before. So they haven't testified to that. We've talked about it on here. Sort of outside the scope of the trial, but they could testify to that. So that's one of the problems. And this disagreement over this moment in time is the key of the case, though. And I think the main point, while both of you are raising, these issues, if the car is not in motion and not in gear and he can't operate it, then the taser is appropriate. If the car is in motion or is in gear, then the taser might not be appropriate. The problem the state has is they haven't had anybody testify that it is in gear.
And Potter would have to know it was in gear. I mean, it's her reasonable perception of events. So if the car's in motion, it's obvious to everyone it's in motion, right? So that can't be ambiguous. But the car was in park when Johnson was fighting with the gear shift. We know that. And then later it went into drive because he drove away after the shot. We know that.
Right.
At the moment she fired the taser, if she reasonably believed it was still in park, well, then for legal purposes, it was in park.
So here's my thing, is that I don't think it's appropriate to say then that it's not the right context to say operating a vehicle when the statute defines operating the vehicle for the purposes of DUI and other criminal offenses, that it doesn't apply to operating a vehicle here, because they could assess with the deployment and use of the taser that the risk is too great that the car could be in motion at the time that you're deploying it, and that you can't assess whether or not the person has actually put the car in gear. So don't deploy it while the vehicle is operating.
But in any case, there is no blanket prohibition on using a taser on someone operating a vehicle. It's not a blanket prohibition.
But there's a policy that suggests against it.
Well, suggesting a suggestive policy is not grounds for a manslaughter conviction. I'm sorry. It's a suggestive policy that has exceptions for officer discretion.
Many of the policies have suggestions for officers' discretion, and officers have been found to either be criminally or civilly liable for not following those policies.
Civilly.
Criminally. Yes, they have.
Show me a case comparable to this one where that's happened.
You can't find a case comparable to every single case. And obviously I'm not going to be able to do that off the fly. But the whole purpose is that either we have officers follow policies or we don't. So here, this officer has to follow.
No, that's not the question. The question is, when they break policy, what do we do to them? Do we fire them and sue them, or do we put them in prison?
Sometimes
that's the question.
in prison. Maybe that's not what should be done here. but it does not mean that that's not the basis of the state's case. I'm not saying that the defense will not come forward and have a great case for why she may not have followed this policy, or she did follow this policy, but say she may not have followed this policy, but it is not equal to criminal liability. I think that there's very likely going to be something here that says that. All I'm saying is that
the policy is don't tase unless other means have proven ineffective. Other means have proven ineffective. She's within policy.
A jury could find that she had other means available to her, such as the fact that they knew who he was, and so they could have let him go and then gone and found him and arrested him later. That's ultimately what the state.
So that's why you let him flee at speed from a traffic light,
clearly
with a woman who may be the protection order victim here.
Say that again.
They also were concerned that there was an order of protection taken out against him by a woman, and they needed to confirm that was not the woman. They can't do that if he flees.
I completely understand that. What I'm saying is that that's your position. The prosecution thinks differently, and it's up to the jury to decide. So all that I'm saying is that that is the prosecution's case.
Well, we're commenting on the strength and weaknesses of these legal arguments, right? That's why we're here.
But it's not, but the way that you're phrasing it is though it's like a per se, it's already concluded type of thing. And all I'm saying is that there's still a question. Sometimes I think that there is no question. Like, I'm like, okay, well, what's the point of this? But I still genuinely think that there's a question depending on what else is brought out in the case.
I think that if that's the state's argument, it's so far distant, light years distance from any proof beyond a reasonable doubt, that I think a conviction would be unjust on the merits. I'm not saying it can't happen. I mean, innocent people are convicted all the time, but I don't see the legal merit that proves guilt beyond a reasonable doubt on that argument when technically her conduct is within policy.
Yeah, I have to disagree with that. I don't see that all the evidence has come out. And so now again, if there's someone that says, look.
Well, different evidence would change the analysis, but I'm talking about the evidence we have in hand at the moment. Her conduct was technically within policy. I don't know how you can disagree. It's a factual policy and we have evidence in hand.
No, because you're saying two things. On one hand, you said that it's within policy. On the other hand, you said that it's just a suggested policy. And the fact that she doesn't follow it doesn't mean that she's committed a crime. She has not followed policy if she's tasing somebody. If she think, and I do genuinely think she thought she was using a taser. So that's why I'm saying taser. Sure. I'm not trying to misstate the facts. So, but if she's tasing somebody while they're operating a vehicle, and either that's
not the policy. You're only reading half the policy. That's why you're struggling here. The policy says don't tase someone in a car unless other means have proven ineffective. That's the policy. So other means have proven ineffective.
I don't agree with you on that. Another means would have been to let him go. That would have been another means.
Well, you can always let them go.
Yes, and the policy allows for her to.
But their job is to make an arrest on a warrant and secure the safety of the female passenger who may well be the woman protected under the order of protection.
But the safety of the female passenger wasn't ensured when he shot and then the car crashes into
nothing is ever insured.
Exactly.
No one knows 100%. That's why being a cop is a hard job.